In contracts, parties may waive their rights to sue one another in court by signing mandatory arbitration provisions that require them to submit their disputes to arbitration. But what if the parties sign multiple contracts with conflicting mandatory arbitration provisions? How does a court determine whether an obligation to arbitrate exists? The United States Court of Appeals for the Sixth Circuit considered this question in Russell v. Citigroup Incorporated. In 2004, Keith Russell took a job as a call center representative with Citigroup Credit Services in Florence, Kentucky. As a condition of his employment, Russell was required to sign a contract that included a standard mandatory arbitration agreement to arbitrate all disputes he had against the company. However, the agreement didn't include class claims. In 2009, Russell left his job. 3 years later, Russell brought a class action lawsuit against Citigroup in federal district court, claiming that the company didn't pay employees for time spent logging in and out of their computers each day. But because the arbitration agreement didn't include class claims, Citigroup didn't seek arbitration. In late 2012, while Russell's action was still pending, Russell reapplied to work at Citigroup's call center in Florence, and the center rehired him. Russell then signed a second contract that included a different mandatory arbitration agreement. The second agreement covered both individual and class claims and applied to all employment-related disputes. Russell didn't consult with his attorneys before signing the second agreement, and Citigroup's outside counsel in the class action didn't know Russell had been rehired. Roughly 1 month later, Citigroup's outside counsel discovered that Russell signed the second agreement and moved to compel arbitration. The court denied the motion, concluding that the second agreement didn't cover lawsuits commenced before it was signed. Citigroup filed an interlocutory appeal to the United States Court of Appeals for the Sixth Circuit.